Nothing is happening in the corridors of power because His Excellency, good morning again, His Excellency John Dramani Mahama is an avowed Democrat, as we all know. He believes totally in the rule of law and due process, and he also believes in accountability, and he believes that everyone must, be granted their rights, inalienable rights that are enshrined in the Constitution. So as far as the corridors of power is concerned, as you describe it, a constitutional process is ongoing. His Excellency has no interest in this matter other than to ensure that due process is followed. As far as we have all been made to understand, there's no breach at all of any part of the Constitution or the President's power by referring this petition, the original 3 petitions that came before him, which he referred to the Council of State. The Council of State met and made a determination that there was a case to be answered. The Council of State further directed the President and advised him to set up a committee to grant the Chief Justice her right to be heard by the same dictates of the Constitution. I think this morning all of us have woken up to the release that the Chief Justice is seeking from our court, and she has the right to use the same fora that she was the head of until her suspension. And I just want to say that I think this 2025 is shaping up to be a very watershed moment in our democracy, and to the extent that we have the Chief Justice herself testing the judicial system, a system that she was, head of, a system that she had defended severally, against concerns and criticisms about the quality of judgments that were, emanating from the judiciary, a system that she defended in times where citizens had raised issues of what they believed was biased, even in the matter of empaneling, judges to hear a matter. And I think that one of such cases she was particularly part of was the not so long matter of the MPs, the majority side then bringing this case to her, and within record time she put together, a team of justices to hear a very highly sensitive political matter. And when issues of bias potential bias were raised about a member of that bench, I think she was quite, intolerant of that.
Just hold your horses there. I know I have to get back to you to continue. We have Martin Kpebu, who is on a mission this morning. He has an activity to undertake, so we quickly just want to deal with him so that he can go off the stream, and then we'll come back to the studio. And Martin Kpebu, now that it is the Chief Justice herself who is the plaintiff, and you look at what she's seeking from the court, what does that then tell you directly in relation to the position she holds on this very matter of her suspension and subsequently the probe that's being undertaken by the committee?
Good. So, number one, it's a sign that she has confidence in the judicial system, or the judiciary to give her justice. Yes, it's a very strong signal that she has confidence that her colleagues on the Supreme Court bench would give her justice. Because if she didn't, she probably wouldn't have gone at all. I was tempted to say she would have gone to the book, but forgive me, let me not even complete it. So the fact that she's going to court, right, is a strong sign that she believes that the system will give her justice. So because of that, let's grant her. It's a constitutional right. And indeed, you find in Article 125 of the Constitution that justice emanates from the people. So the people give justice, and so when they have issues, they have grievances, they also will go to the court to ventilate their claims. So it's okay. The only thing is that the optics are very bad in her choice of Godfrey Dame as lawyer is terrible. I mean, I can't believe it. People had made comments earlier on, so I thought the Chief Justice would have taken a cue. You know?
Why?
Dame was in this Japa tape, did a lot of unethical things in the Japa tape, was suborning witnesses, coaching a witness to go and lie to the court, asking the witness to get a fake medical report, you know, saying that Ekufuado and Ofuriata were on his neck to use the judicial system to prosecute Atuforsen and Japa. All right, so that's persecution, using the judicial system for their own political ends, everything. And the tape is official. It was admitted in evidence in court. So for the rest of Godfrey Dame's life, that tape is him. Whether the case goes to the General Legal Council or not, whether he is found liable or not, the judge, Justice Ifia Sewa Asaribuche, admitted the tape as authentic. So for a lawyer who has done such a thing, and many lawyers are saying he should be sanctioned by the General Legal Council, and yet he has so far escaped it. The Chief Justice choosing Godfrey Dame as a lawyer begins to raise a lot of suspicions. We are like, okay, so is it because of the alliance that Godfrey Dame didn't appear for the General Legal Council, that Godfrey Dame has not been sanctioned? She should have seen all of that. All of that. I mean, and look, trust me, Mr. Walker, other things will come up. Other news and information will come up that will make this choice more terrible than it already appears. So the best for the Chief Justice to do is to disengage Godfrey Dame. Godfrey Dame leading her in this case is a terrible engagement. It's a very terrible one. Look, there are other things that, as I said, I will hold my horses, but this is not on. Godfrey Dame has to be disengaged. You see, for Godfrey Dame, this case is also serving as a rehabilitation for him. You know, because of the terrible things he did in the Japa tape, he thinks by coming to court, wading into these conversations, and people talking about it, after a while, we will stop talking about the Japa tape. But it's a lie. We will not stop talking about that Japa tape until Godfrey Dame is sanctioned by the General Legal. That is the disciplinary committee of the General Legal Council. So it's like that's the court where lawyers who breach their ethics are sanctioned. So once the tape has been admitted, the tape is been shown to be authentic, Godfrey Dame must face justice for those things. So he thinks by taking on these cases and by being the center of public attention, comments, etc., very soon people will start talking about the tape. It won't stop. So he better just prepare to face justice. So this is what I can say in terms of the situation so far.
Looking at how the Supreme Court has dealt with the previous suits or petitions, so to speak, in relation to this subject matter, and then subsequently the suspension, the processes in all, do you think there's any merit in this current one at all by the Chief Justice herself? Okay, so this has been asked, Mr. Walker, this one, you know, because of the issues of contempt. Right now, our society is doing better. We are commenting more. So we are narrowing down the borders of contempt. But this one is too direct. It's too direct. So you mean my question? My question is direct.
I say too direct, too near the contempt matters.
Okay.
I'm not allowed to say that. I don't think.
All right. So let me perhaps rephrase my question then, so that we make it more of a public discourse. If you take a look at the public opinion that seemed to have greeted, or the public opinion that had been elicited as a result of the last 3 dismissed cases in relation to the subject matter so far, why do you think the public opinion seemed not to favor the Chief Justice?
Okay, good. Yes, that's a brilliant question. You're a wise man. Good. Now, public opinion doesn't appear to favor her because of what people have read in the petitions, and most especially to you know, the case involving the Speaker of Parliament, Afenyomakin's case against the Speaker of Parliament. You know that case, when we analyzed it, we saw that the Chief Justice chairing the panel, presiding in that panel, rushed the case too much, that he raised too many suspicions. So you see, she lost a lot of, what do you call it, confidence. People lost a lot of confidence in her from the manner in which she treated the Speaker, the removal of the 4 parliamentarians case. That's Afenyomakin versus the Speaker case. So, you know, it just, you see, even I think Shamima Muslim referred to it. There were parts of the case where she appeared too aggressive, etc. So that was the beginning of her fall. That's the beginning of the fall. Because you see, human beings, yes, the citizens may not be lawyers, but they are not stupid. They can see where you aggress a lawyer and do other things openly. You know, they tell that a picture is worth 1,000 words. They can see. They can see. So I think that is the case that, I mean, really is fueling the lot of public disfavor, the lot of lack of support for a cause. Because you saw the polls Musa Dankwa did, where 52% of Ghanaians said that she be removed, and only 18% opposed it. I think you can check the figure. Yeah, not more than 20.
53.
No, those who go ahead.
53%, and then about 20%. But however, but however, he did say that among the MPP, the majority of them, by way of the respondents who are politically aligned to the MPP or the opposition, they over 80% or about 80%, so to speak.
Yes, that one is to be expected because, you know, look, let's not hide this. Appointment as Chief Justice is a political appointment, right? And politicians are known to choose their friends. Politicians don't choose their enemies generally. Generally, they don't choose enemies, okay? Or they don't choose neutrals generally, all right? So they will choose people they trust any day will have their back. So if 80% of the active MPP people think that she should not be removed, I understand. It's their opinion. So let's grant them. So as I mentioned, is the case, the Speaker case and everything. So citizens have a right to also weigh in. So if they say they are not supporting it, it's unfortunate. It's a lesson to all of us that, hey, the power of the citizen, we have to be very careful. You may have all the power, but it's not every power you exercise. You see, like it's said in 1 Corinthians 6:12, there is that thing about all things, everything is permissible, but not everything is beneficial. So today you may have power over somebody, but you have to always think about tomorrow. So that when you're dealing with the person, be extremely, careful that, hey, this is what I'm doing today. Is this person likely to, be affected negatively, and so I'm likely to pay for it tomorrow,
Okay, Mr. Kpebu.
Yeah.
The last one I'll ask you, there seemed to be the regurgitation or the re-echoing of her comments publicly when addressing, I think it was a women's event or so, that the law is the law, irrespective of, she put it, the noises that will be made, even though as much noise that will be made, that will be more appropriate. Don't you think that using that quote that she made to be the responsive argument for her not to challenge the ongoing processes is not fair to her?
Oh, absolutely, yes. So it's not fair to her to say that she shouldn't challenge the law. Yes, when she says the law is the law, yes, it also means that, yes, from time to time, if you think that, so when they do an interpretation that favors you, the meaning is that that interpretation was always part of the law, but we didn't know it. You see, the Constitution is language. You see, the Constitution is written this in the English language. Of course, you ask experts and they will tell you the English language, like any other language, also has its limits. So it's not, you won't always find the perfect word for every situation. Yes, the English language has its own limits. It's not the only I mean, most languages, right? So all I'm saying is that, so you can't find the most perfect word for every situation in the Constitution.
Okay.
So certain phrases and terms in the Constitution don't look like they fit them proper. So, and some to have hidden meanings. Yes,
Okay.
let's make this word. Especially the word fair in Article 19. Fair. It has a lot of hidden meanings. So what I'm saying is that the law is the law. So when the Supreme Court interprets the law or any other court, that new interpretation has always been part of that law. It's not new. So it's okay. Let us challenge the system. But Mr. Walker, what we are walking away with, okay, is that our system through this public debate eventually will become stronger.
Okay.
The only thing is that in the short term it's going to create a crisis of confidence because you are talking about the Chief Justice. So, and then by extension the judicial system. So it's going to in the meantime reduce confidence in the judicial system because they'll be like, oh, can't we solve the situation? Can't we solve the situation? Why do we allow this to fester? That's why for me I keep saying that Chief Justice Torkonoo can help the system by resigning. It will be very beneficial. Yes, it will help us.
Okay.
So that, yes, so that the fight, at least she's fought enough, there's been public debate enough, then, I mean, the system can begin to heal.
All right. Thank you very much. The quotation from, is it Corinthians? Please, I want to keep that. What's the quotation again? Do you remember?
Yes, 1 Corinthians 6-12, that area. Everything is permissible, but it's not everything that's beneficial. Everything is permissible. Yes, you have a right, but it's not everything that's beneficial. So sometimes you look at your right and you say, no, I walk away because of the interest of the larger majority, the interest of the society, the public interest. I will forego this, my right.
All right.
So if Chief Justice Torkonoo were to resign, that would be a good application of the principle.
I get your point, but thank you so much. Which church do you attend? Since you've been quoting, because the last time we had a public official quoting was Kenuforiata, Bibles on and on. So which church do you attend?
I'm a Catholic at St. Thomas Aquinas, University of Ghana.
All right. Okay. I wish you well, sir. Martin.
Thank you, Mr. Walker.
Yeah.
Good.
Hajia. So it looks like
Martin has said a lot of the things.
Yes,
but that's a good context.
Yes,
and it's good that it's coming from him and not say a government spokesperson. But you see, truth, and objective truth. It's something that is very easy to sell. And again, for us as a government, you know, when we say words have meaning and they are powerful. When His Excellency, ahead of the 2024 election, says that his entire vision for seeking a renewed, another opportunity to leave this country was about resetting this country, many people didn't understand. And here we are. The events subsequently are all contributing to justifying why it is very important to reset, Ghana, to reset our institutions, to reset our structures and our systems, to reset our attitudes and our behaviors. And it couldn't have been happening at the right time, because this is obviously the right time, a time where a Constitution Review Committee is hard at work, engaging various, stakeholders to figure out which aspects of our Constitution do we really need the reforms to happen as quickly as possible. And to the extent that the head of the judiciary is today herself testing the judicial system, I think one of the things she can bequeath to this nation is to also now submit a memoranda on the Constitution Review Commission, committee.
Are these your personal views?
These are my, of course, I'm here. I'm saying, like what?
You are a presidential staff and spokesperson. So when you
speak
like
bring
that,
us here, I don't think I've said anything out of sorts. I'm saying that this is the right time for the Chief Justice to also submit a memoranda to the Constitution Review Committee, because she's testing the system. I don't think she's ever had an opportunity like this to actually test the system that many Ghanaians have tested and many Ghanaians have had opinions about, opinions that sometimes she's had cause to defend, against or to speak against over the years. And many lawyers who have interfaced the judicial system have had opinions about our justice delivery system and some of the challenges. So it is good time for our democracy that these things are happening, that we have none other but the personality of the Chief Justice, now suspended, going through. And again, Martin made a point that I'd also put down last night when I was reflecting that, there's no other forum other than the forum of the judiciary to seek justice and redress. And so we must all be interested in our justice delivery system, because to even bring the matter to the courts is an indication that you do have faith. And you would have expected that as a Chief Justice, your faith in the judicial system would have leaned you towards allowing the due process to complete, after which, if you now believe there's been some miscarriage of justice, to then again activate the avenues available to you within the same judicial system to seek redress. But any which way, as I said earlier, she does have a right. And for government, we know that the president has not breached any constitution. The president is awaiting the work and the outcome of the committee that has been set to look into the matter and to provide a hearing to the Chief Justice. Again, all these other court cases, as we have known in the past, sometimes delay the process, but the process would go on anyway. So she has a right to do that. If you look at the optics of Godfred Dame, actually I'm not surprised, because I think that there's a certain level of guilt that the New Patriotic Party and its leaders.
What has he done wrong? He's just a practicing lawyer.
Let me wrap up. Yes, but he was the Attorney General in a not so distant past, an Attorney General that many people believed did not exercise his duty to the people of Ghana. He did not come across as, holding fiduciary to the constitution per his actions and his behaviors that are in public domain. So I think that the NPP feels a certain level of guilt, because it is they that has brought the image of not only the judiciary but the Chief Justice into public disrepute, because it is they, through their actions, that have literally caused the Chief Justice to take certain actions that today many people believed were contrived to procure a certain outcome in favor of them. So it goes without reason that they will be interested in trying to help her in this moment that they believe is a difficult moment. But whether that is the right optics, I think the jury is out there for many Ghanaians that perhaps it may not have been the most prudent, strategies to use a former Attorney General who was accused of manipulating the judiciary to now be your number one advocate and defender as a head of the judiciary. Because in the same breath that you indicate that there's separation, or there should be separation of powers, then you're calling per your reliefs for a discontinuance of a constitutional process, that has backing with the constitution based on what you believe is an unfair forum. That same thinking should have guided the choice, because Godfred Dame was a member of the executive. What business does a member of the executive, not only a mere member of the executive, the president's and the government's lawyer and legal advice, what business does he have to do with defending the head of the judiciary? The same logic applies. And if you look briefly at some of the relief she's seeking, amongst others, to not go into the merit of the case, but to throw it out there for all of us to think through, the public hearing, for instance. She insists that she prefers a public hearing of the matter, which we know, per the Constitution, as you have also read, in Article 1468 that the proceedings shall be held in camera. Lawyers have spent copious amounts of time explaining to us what the injunction shall means. And to the minds of average Ghanaians, shall is obligatory rather than discretionary. So that is a curious, relief to be sought by the Chief Justice. And it's not only in her interest that these matters have been prescribed to be held in camera. It is also in the interest of the protection of the institution,
the office in
itself, the protection of, say, the petitioners, because she would see who her petitioners are.